Good afternoon. This is a series of lectures related to Indian Partnership Act. The Indian Partnership Act 1932. I am Dr. G. Mallikarjun. First, partnership is one of the forms of business organization. So the business that can be conducted by individuals or enterprises can be conducted either individually, where it could be something like a sole proprietorship firm, or a family could do the business, which could be in the form of an organized structure like a Hindu undivided family, or it could be in the form of a association of individuals. So people come together and form a club, etc. They could also do some activities, or they could engage in a business as well. Then organized forms of conducting business are partnership firm, where the first of the kinds of partnerships that were there were basically those which had joint and several liability. So, and the liability was unlimited. So this was the structure of partnership that was there, basically between persons who had a good understanding amongst themselves and had an intention to work together for doing business and have an agreed mechanism of operating in the form of sharing their profits, etc. But since joint and several liability was an issue and the liability was unlimited, there was a need for looking out for another form of business organization. And this is where the concept of companies came about. And this brought in two important changes. One is limited liability to the extent of the shareholding of the persons who are members of the business organization. Second is a perpetual succession. While a partnership, Hindu undivided family, or a sole proprietorship, etc., depend heavily on the person's presence and the composition of the persons that are there. There is no perpetual succession in those cases. But a company is an entity which is doing business in an independent manner, because of which it will have perpetual succession. So whoever may be the management, whoever may be the promoter, if he is there or not there, this corporate entity structure of the company will continue. So because of these two unique features that are there, that is limited liability either by guarantee or shares, and second, perpetual succession and a distinct corporate entity apart from the persons who are promoting it or running it or managing it. So that made company one of the most preferred form of business organization. And now you find in those you have various categories: private limited company, public limited company. Then where government has substantial ownership, you have a government company. Then you have companies limited by shares, where the extent of liability is to the extent of share contribution that has been made into the capital. Then you could have companies limited by guarantee, where you don't you are indicating that I will be guaranteeing the payment of a certain amount. So these are the various types of companies that you could have. Then special categories of companies are also provided for in the Companies Act, like your Section 8 company, etc. With the coming into force of the Companies Act, you now have a different concept of a company called as a one-person company. So instead of having a sole proprietorship firm, the sole proprietor could now get himself constituted as a one-person company and operate in a corporatized manner as a company. Then for professional organizations, especially, to have the benefit of limited liability, but continue to have the structure of a partnership firm with certain additional features, a legal provision, a legal enabling framework for these kind of partnerships where limited liability is provided for. We have the limited liability partnerships, or the LLPs, through the Limited Liability Partnership Act. Then corporation is another form of a body corporate that is there, where the setting up of this entity for doing business will be either by an act of legislature, be it a central legislature or the state legislature. That is, these are entities which are created for the purpose of doing specified business under the act of legislature. So a parliament enactment could be there, like your NABARD, the National Bank for Agriculture and Rural Development, Life Insurance Corporation, then your Rural Electrification Corporation, Power Finance Corporation, Tourism Finance Corporation. So these are all corporations which are set up under an act of central legislature, that is the parliament. The other kind of institutions that you could have are those which are set up under the state legislation, like your state financial corporation, state industrial development corporation, etc. So these are corporations, corporate bodies which are set up based on the enactment, and this enactment is passed by the state legislature. So these are basically statutory bodies. Then the other traditional mechanism of business organization is something called as a cooperative society. It started off with the 1905 Cooperative Societies Act. Internationally, especially in Europe, it was very popular. So we adapted that to our country. Then the legal framework for cooperation and constitution of people together in the form of a society was brought about through the 1905 Act. Then we had the 1912 Act, where even for doing banking business, these entities were permitted. So the cooperative societies are also entities for are a form of business organization. And in that you have cooperative societies of the state. Under the State Cooperative Societies Act, they could be registered, or those which are operating across states, you could have them registered under the Multi-State Cooperative Societies Act. Then in the microfinance era, a new set of cooperatives came, which were coming under another enactment of cooperative societies called the Mutually Aided Cooperative Societies Act. So some of the states like Andhra Pradesh, etc., have this Mutually Aided Cooperative Societies Act, which is dealing with providing lesser control over registrars and enabling the members to control the operations, business, etc. of the cooperative. So the major forms of business organizations are Hindu undivided family, where the Karta will be the person who will be administering the whole show, and he will be responsible, and he will be in a position to deal on behalf of or work for the organization. Then sole proprietorship firm, one person pooling whatever money he has or using whatever money and then mobilizing money which he can raise through borrowing, etc., and doing his business. Then a partnership firm, people coming together and then working based on agreed principles and having a defined mechanism of sharing their profit. The traditional partnerships under the Indian Partnership Act are unlimited liability partnerships, where the liability of each partner will be joint and several. Then you have limited liability partnerships under the LLP Act, where the liability is limited, but they also operate in an agreement, based on an agreement with sharing of profits, etc. Then in the companies, you have a one-person company, private, public, government, producer company, all Nidhi company, etc. So depending upon there are special classes of companies, and Section 8 company, not-for-profit organizations, etc. Then corporations, for basically doing those acts which the state wants to do or promote. Then cooperative societies, members operating for mutual benefit by the people, of the people, and for the people, like the by, of, and for the members. So all these institutions have distinct features, which are, some of them are pluses, some of them are minuses. But which form of business organization one has to choose for doing his business will depend upon an assessment of the pros and cons of each form of business organization, and accordingly, the next step in terms of constituting a business organization will take place. So partnership is the form of business organization that we would like to talk about. Then first, co-ownership is also a mechanism where a set of people will have ownership over certain assets. So example, there is a property on which two people have taken mortgage. Two people have given loans against the security of mortgage. So now the person does not pay the money. So automatically these two people will take over possession of that. So can they be called a partnership firm? Because they are going to be doing this, and then they will be taking over, and they will be selling it. So they are not partners, but here they will be getting the ownership of it. Joint ownership or co-ownership will be there. Similarly, when a committee of creditors takes over the entire management of a company which is into the corporate insolvency process, so they will also be like co-owners. So can you call this committee of creditors to be a partnership or not? So what are those elements which distinguish a co-ownership from the partnership? We'll try to see. First, partnership is something which can happen only by an agreement, not necessarily written, but it could be either oral or written or partly oral and partly written. In case of a co-ownership, there could be or may not be an agreement. And generally, co-ownership comes out of inheritance, like what is it? A group of a family set of family members. So the person dies, so he has sons and daughters. So they will initially have the co-ownership over the inheritance. So depending upon how it is supposed to be distributed, if there is a will, then the distribution will be in accordance with that. Otherwise, it will be based on the partition, and that mechanism will be operational. So it's not necessary there should be an agreement, or there may not be an agreement also. Another instance of co-ownership is enforcement of security and taking over, etc. Then for a partnership, doing business is necessary. So there cannot be a partnership for merely sake of having a partnership. There has to be a business, and there has to be an objective of generating profits and a mechanism of sharing these profits. In case of co-ownership, there is no necessity for having to do business as a requirement. Then the important principle that is there in partnership is all or one, or the partner's agent acting for all. So each person in a partnership firm will be an agent of the other and principal insofar as the other partners are concerned. So this relationship of mutual agency is something which is very, very essential. But in case of co-owners, they don't operate on the basis of this mutual agency. Then a partnership, in a partnership, a partner cannot sell his share without the consent of others. So there are certain things which a partner can do, certain things which he cannot do, and the terms can be drawn up in an agreement. But a partner cannot sell his share without taking the consent of others, unless it is provided for in the contract, which again is something which has been drawn up based on the consent between the persons. And a co-owner can sell his share without the consent of others also. Suppose there is a person who is having security, that portion of the security he can sell to someone and get out of that relationship. But it's not so easy to get out and sell the share in case of partnership. Then a partner can sue partners for dissolution and accounts. A partner who is not satisfied with the conduct of the business can sue the other partners, or he can file for dissolution and call for accounts and distribution of whatever partnership property is there. In case of a co-ownership, there is no case of, they cannot sue for partition. They only have to get the proceeds, and they will have to be realized. They will have to be realized and their shares distributed. Then a partner has lien on the firm's property. Because it's joint property, there is a lien on it. In case of a co-owner, he has no lien on the joint property. So he does not have a security or a charge on the property for recovery of whatever dues are there. In case of firm property, it's automatically a joint property of all the partners, because of which there is a lien on the firm property. Then any partner who is operating in a partnership firm has an implied authority to bind the firm. So there are provisions relating to implied authority under the Partnership Act, and there are exceptions to it and modifications that can be made, restrictions or enhancements that can be made by agreement again. So otherwise, for the acts of the firm, generally, there will be an implied authority of the partner to bind the firm, because this is where the mutual agency principle operates. In case of co-ownership, the co-owner has no implied authority to bind other partners. So this is as far as the distinction between partnership and co-ownership. This is something which is asked because partnership is not based on the titling of it, and it is not co-ownership, is not partnership, and you have to look into the mechanism of operation of a partnership and the agreement to understand whether something is a partnership or something is a co-ownership. So this is generally something which is asked, and in relation to this, these are the distinctions between a partnership and co-ownership. Then the next part of it is, what is the difference between a partnership and a joint family? So a partnership is created by an agreement, whereas a joint family or a Hindu undivided family is created by birth and not by a contract. Then entry of a partner is based on the agreement or consent of all the partners. Then only in case of a minor, if agreed again by all the partners, he can be entered for the purpose of benefit. In case of a Hindu undivided family or a joint family, entry is basically by birth. And the sharing of profits may not be equal in case of a partnership firm. But in case of a Hindu undivided family or a joint family, each member gets equal share of the assets and profits. In case of a partnership firm, you could have different levels of profits sharing mechanism agreed between the different partners, depending upon what they have brought in, depending upon what capabilities or work they do in the partnership firm, etc., which is all by agreement. In case of a joint family, everyone gets an equal share. Then new partner cannot be admitted without the consent of other partners, and a new partner here joins merely by birth. Then mutual agency is a very essential part in case of a partnership, but here in a Hindu undivided family, it's not that every co-partner or member is capable of deciding for all. It is only the manager or the karta who decides, and he is the representative of the family. There is no mutual agency operating in a Hindu undivided family. Then partner has an unlimited capacity to bind the co-partners into liability, which is the playing out of the mutual agency. So when he is acting as an agent, and all the other partners of the firm will be principals, and they will be bound by whatever he is doing. Then members of the family do not have the capacity to bind the others into liability. It's only the karta. Then liability of the partner in case of a partnership firm is personal and joint. In case of a joint family, the co-partner is not personally liable for business obligations of the family. The liability will be of the Hindu of the karta. Then a partnership, in a partnership firm, a partner can sue co-partners for dissolution and accounts. Here, a co-partner or a member of a Hindu undivided family can seek partition and sever the relationship and take his share and walk out. Then the differences between partnership and a limited liability partnership. So while partnership is not a distinct legal entity and it has got no perpetual succession, a limited liability partnership has a distinct legal entity. So in that way, LLP is a better form of business organization for certain purposes when compared to a partnership firm. Then a partnership firm cannot contract in its own name. This is an incident of being a legal entity, but an LLP being a legal entity can contract, can sue and be sued as a limited liability partnership. And in case of a partnership, there is no specification as far as the name is concerned. The only thing that is provided for in the registration chapter of the Partnership Act is that certain names like Crown, etc., cannot be used in a partner's name, because people should not get a feeling that this has got government patronage. But there is a requirement. Other than that, there is no specificity in terms of what should be the name of a partnership firm. But in case of an LLP, it is necessary that the name should have LLP in the name of the partnership firm. Then a partnership cannot hold property in the firm name, whereas an LLP can hold property in firm's name. Then again, there is no perpetual succession for a normal partnership, but there is a perpetual succession for a limited liability partnership. Then rights and liabilities of the partners are based on an agreement, and this agreement need not be in writing. It could be implied as well. Whereas in case of a partnership, limited liability partnership, the rights and liabilities are as per the agreement, like a partnership firm, but the agreement has to be in writing, and it has to be registered within 30 days of incorporation of the partnership firm. Then the minimum number of partners that you can have in a LLP or in a normal partnership is 2. However, in case of an LLP, there has to be 2 managing partners also. If there are 2 partners only in an LLP, then both of them are managing partners. Then the maximum number of partners in case of a normal firm is 50, which is in accordance with the rules of the Companies Act. In case of a limited liability partnership, there is no limit in terms of how many partners you could have. Then registration of firm is not mandatory in case of a normal partnership. The only thing that is provided for is under section 69, where there are certain effects of non-registration, which are intended basically to ensure that the firms get themselves registered so that they can sue and they can sue the partners, etc. So you don't get the eligibility to sue third party or partner in case there is any problem. The only remedy that is available is to cause for dissolution. So that's the reason why registration is not mandatory, but having registration is good. In case of a limited liability partnership, registration is mandatory. Then annual return is not specified for a limited liability partnership, but there is a requirement under the LLP Act that an annual return is supposed to be registered, is supposed to be sent to the registrar within 60 days. Then audit is not mandatory in case of a partnership firm. Audit is mandatory for companies which are having 25 lakhs size or 40 lakh turnover. Then the most important distinction is that a partnership firm has got unlimited liability, joint and several, whereas in case of a limited liability partnership, as the name goes, the liability is limited to the capital that has been contributed. So this is these are the differences between an LLP and a partnership. So the next thing is, what are the differences between a partnership and a company? So as reiterating, it's not a distinct legal entity. A company is a distinct legal entity. We have seen Solomon versus Solomon's case, which talks about company being a different entity. And there is a corporate wheel. You can't lift the wheel unless certain conditions are there. Second part of it is, a partnership is an unlimited joint and several liability of the partners. In case of a company, the liability is limited by shares or by guarantee. Then death or insolvency of a partner affects the continuance unless the partnership agreement provides for it. Whereas a company has perpetual succession. So whoever the promoter or management shareholder, whoever dies, there will be a succession as far as the company is concerned. It's a going entity. Then partners are co-owners of the firm's property. So though technically the company's property belongs to the members, etc., but it's not generally referred to as co-ownership of the company's property. It's not generally used in that sense. Then the share of partner is not transferable without the consent of the partners. So here the shares are freely transferable. And depending upon whether they are listed or not, etc., also you could have different kinds of companies and the regulatory requirements that are there. The conduct of business of a partnership and the mutual rights and liabilities are determined by an agreement. In case of a company, the conduct of business, the share capital, etc., will be determined by the memorandum of association, and the operations of the company, etc., will be determined by the articles of association. So these are the important documents. Then incorporation is by the certificate of incorporation. Then in case of private limited companies, you need to have certificate of commencement of business as well. So these requirements are not there. It's just an agreement which need not even be in writing, and it need not be registered also as far as a partnership is concerned. Then the minimum number of partners is 2 and the maximum is 50. In case of a company, you could have a one-person company also. Then you could have, for private companies, the maximum is 200. In case of public companies, there is no limit in terms of how many members a company can have. Then registration is not mandatory, though there could be defects which would, effects of non-registration which could come into play. But in case of a company, registration is absolutely essential. So now, going into the specifics of the Act. Partnership Act is Act 9 of 1932. The long title of the Act says it's an act meant to define and amend the law relating to partnership. So where was this law prior to partnership being in the Partnership Act? It was a part of the Indian Contract Act 1872, and Part 11 of the Act dealt with partnership, and this Part 11 has been repealed and replaced by the Indian Partnership Act 1932. And similarly, the Sale of Goods Act was also initially a part of the Contract Act. Subsequently, a new act was brought about in 1930. So the act was enacted on 8th April 1932, and it came into force from 1st October 1932. Except section 69, And this section 69 deals with effect of non-registration. So because there is certain specificity attached to the effect of non-registration, a period of 1 year in case of the Act is largely designed based on the English Partnership Act. But in case of an English Partnership Act, registration was mandatory. But considering the nature of our country, it was decided that let us not make registration mandatory, but let us make it incentivize registration by people by bringing about some effects of non-registration. That is, you cannot, if a partner cannot take up any litigation against the partners of the firm unless the firm is registered. Second, he cannot take up any litigation for enforcement of any contract against a third party unless he is registered, the firm is registered, and the person who is named as a partner. So these effects make it necessary that if I have to have a legal recourse, then it is better that I am getting myself registered. So for that disability to operate, a period of 1 year was given for the firms to get themselves registered so that they are not subject. So that's the reason why Section 69 became effective from 1933. Then the scheme of the Act, there are 8 chapters in the Act and sections running from 1 to 74. There are 2 schedules which were originally there. Now there is only 1 schedule. And that schedule talks about maximum fee, which is under section 71(1) of the Partnership Act. Then since partnership is listed in list 3, that is the concurrent list in the 7th schedule of the Constitution of India under Article 246. So that's the reason why both the center and the state have powers to legislate in this regard. While the central legislation operates wherever there is a need that is required by the state in relation to partnership firms, the state can come out with specific recommendations or amendments. One of the important example is Maharashtra registration is mandatory, whereas in other states the registration is not mandatory. The extent of fees are different for different in different states, etc. Then what is the title of this item is list 3, item number 7 deals with contracts including partnership, agency, contracts of carriage and other special forms of contract, but not including contracts relating to agricultural land. So this is the scheme of the Act. Then section 11, the scheme of the Act in terms of the various chapters are, chapter 1 talks about preliminary aspects like, and it is from sections 1 to 3. Chapter 2 talks about the nature of partnership. What is a partnership? What is a firm name? Who is a partner, etc. And then what are the aspects relating to partnership at will, etc. So sections 4 to 8 deal with the nature of partnership. Then what is the relationship of partner to one another? The mutual agency aspect, liability aspect, etc. Then good faith related aspects, rights and duties of partners vis-a-vis other partners. These are all contained in sections 9 to 17 in chapter 3 of the Partnership Act. Then chapter 4 deals with the relation of partners to third parties. So what is implied authority? Then what are the extensions of implied authority? What could be the restrictions? What is the operation relating to that? What is holding out? So what is the effect of a minor being admitted to the partnership, etc. So what are those aspects where a partnership is dealing with the outside world? What are the relationship of partners with the third parties in the outside world? That is what is covered in chapter 4, 18 to section 30. Then chapter 5 deals with incoming and outgoing partners. So you could have partners coming in. The mechanisms of partners going out is 1, retirement, 2nd, expulsion, then 3rd, by insolvency, and 4th, by death. So these instances, what are the mechanisms, what are the effects of people coming in and going out is all discussed in section 31 to 38 in chapter 5. Then chapter 6 talks about dissolution of firm. What are the mechanisms of dissolution of firm? By contract, by happening of certain events like death, insolvency, then dissolution by court in certain instances. So all those aspects. Then how do you distribute the firm's property, individual property, how the profits are apportioned between people? All this is provided for. And what are the effects of dissolution of a firm These are all discussed in sections 39 to 55, chapter 6 of the Partnership Act. Then chapter 7 talks about registration of firms. So registrar for this purpose, then what are the changes that need to be made that has to be carried out, then a statement to be given, etc. for registration. Then what are the effects of non-registration, section 69, etc. Then what is, so all these aspects relating to registration changes, then the admissibility of the records as evidence, etc. are all discussed in chapter 7. Then chapter 8 talks about supplementary matters, and one of the section 72 is very important, which talks about public notice. Then section 74 talks about rules, etc. So these are the important aspects. This is the structure of the Partnership Act. Then now coming to the preliminary aspects, chapter 1 deals with sections 1 to 3. So the short title, commencement and extent, is the content of section 1. So the short title is the Indian Partnership Act 1932. It is applicable to whole of India and it is effective from 1/10/1932. So as I already told you, section 69 became effective from 1 year after the act came into effect. That is from 1st October 1933. Definitions, one of the most important definitions that is there is what constitutes an act of the firm. So any act or omission by all partners or by any partner or agent of the firm giving rise to a right enforceable by or against the firm is an act of the firm. So this act of the firm becomes very important for the purpose of liability of the partner insofar as the third party is concerned, and liability of the other partners in relation to the partner if he does something, etc. So the mutual agency principle, etc., will operate only in relation to the acts of the firm. So an act by all the partners. So what is an act of the firm? By all the partners or one partner or an agent of the partner. Any of these can be act of the firm. And what will be the impact of an act of firm? It will create rights and liabilities with respect to third parties. Then whether an act or omission is an act of the firm or not is basically a question of fact, and it has to be examined on a case-by-case basis. You can't say that everything that is happening or done by a partner is an act of the firm to hold the partner and other firm liable. So that's the reason why you have to see the facts of the case to see whether something is an act of the firm or not. The second important aspect is business, because a partnership can be there only for the purpose of carrying on a business. So what is this business? The definition says that it is every trade, occupation or profession which is the business. Then second, it talks about prescribed. So what is prescribed? The prescribed means rules made under the act under section 74. Then third party, any person. So as far as the liabilities, etc., and interaction with the third party during the course of business in acts of the firm, etc., we refer to third party. So what is third party? In relation to the firm, it means any person who is not a partner in the firm will be a third party. Then another part of it is this, wherever there are any expressions which are used in the act, but which are not defined in Partnership Act, because there are only 4 definitions, but which are defined in the Indian Contract Act, will have the same meaning assigned to them in that act. So act of firm and business have implications in respect of relation of parties to third party. Then going further ahead, it is indicated that partnership is also an agreement, and an agreement enforceable by law is contract. So the Contract Act provisions are applicable to the partnership related issues also. So the unrepealed provisions of the Indian Contract Act are continue to apply to the firms. When will they not continue to apply? Only when they are inconsistent with the express provisions of the Act. So where the express provisions of the Partnership Act are there, and there is a provision which is there in the Contract Act, and this provision in Partnership Act is at variance from the provision in the Indian Contract Act, then Partnership Act will apply and Indian Contract Act provision will not apply. But where the Partnership Act is silent, the provisions of the Indian Contract Act will apply. Example, like a minor. Minor cannot be a party to a contract. So that will be applicable here also. But minor can be admitted into the partnership, and there are certain aspects of liability that will be governing a minor in a partnership firm, that is under section 30. So in that particular case, Partnership Act provisions will apply. Then there is an ability for a partner to be subjected to an agreement in restraint of trade. But section 27 of the Indian Contract Act says that any agreement in restraint of trade is void. But here there is an express provision saying that while in a partnership firm, I can have a clause saying that nobody in the firm will do any business other than the business which the firm is carrying on. Someone goes out, then I can say that you should not be doing this business that that the firm is doing for this period in this particular area, etc. If it is reasonable, it's okay. But if I'm indicating these kind of things in a partnership agreement, I'm violating section 27 of the Indian Contract Act. But because there is an inconsistency between 27 and the Partnership Act, the Partnership Act provision will apply and the Indian Contract Act provision will not apply. So only if they are inconsistent will the Partnership Act provisions not apply. Otherwise, the provisions of Partnership Act will apply. The provisions of Contract Act will not apply. If they are not inconsistent, Contract Act provisions will continue to apply. Like free consent for an agreement, then consideration, all these aspects relating to contract will apply. So this is as far as the introductory part is concerned. Thank you.